This video is about how to win a drink driving case. Now there are four main ways to win a drink driving case. The first and most common way is to rely on what's called an unsafe reading. Now, in order to find you guilty of drink driving, the court must find that at the time of driving, rather than later when you're tested, at the time of driving, your blood alcohol concentration was at a particular range, particular prescribed range. Now, normally if you're taken to the police station, it will be approximately 40 minutes or an hour after the time that you're driving. So they will take your breath analysis there at the police station and the reading will come up on the machine. Now, whatever reading comes up on the machine, that does not mean that at the time of driving, 40 minutes or an hour before, you had that same reading. Now, there have been many studies to show that your blood alcohol concentration, or BAC, goes up for 40 minutes or an hour after you take alcohol. So for example, if I were to drink a few drinks and then jump into my car and I started driving, that alcohol may not be at the same range, it may be at a lower range than 40 minutes or an hour later. So that's the first way to defend a drink driving charge. It's called unsafe reading. Now, how do you do that? The way that you do that is to obtain what's called a pharmacological report. It's a report which assesses your weight, your sex, how much you drank, what you drank, when you drank it, things like that. And it comes up with a reading at the time of driving rather than later when you were taken to the police station for a breath analysis. Now, if you get a pharmacological report and it comes up that your range, your blood alcohol concentration was lower when you drove, then we can send that to the police and ask for the withdrawal of the charge on the basis that you are under the prescribed range of alcohol. Alternatively, we can ask, for example, that a charge of high range drink driving be reduced to a low range, such as mid range or low range, depending on the outcome of the report. Now, if police refuse to withdraw the charge, we can fight it in court for you on the basis of the pharmacological report and the expert that would have to attend court that day. That's the first and most common way, unsafe reading. The second way is called the 2-hour rule. Now, a lot of people know that police must test you at the police station within 2 hours of driving. So, for example, if you were pulled over at 11 p.m. and police weren't able to test you until 1:30 a.m, then that testing at the police station, the breath analysis, would be inadmissible in court, can't be used in court. So that's called the 2-hour rule. The third way is called the home safe rule. So that means that if you've driven and you're on your own property at home, then police can't test you on your property. That's the home safe rule. Finally, there's something called honest and reasonable mistake. Now, honest and reasonable mistake means that you didn't know, you made a mistake as to your reading at the time when you drove. Now, there's a lot of publicity about drink driving, so it will be hard to prove what's called honest and reasonable mistake. A lot of mistakes might be honest, like I might have a drink or two and then, inappropriately of course, you wouldn't drive, but if I may have a drink or two and then drive and then say, look, I honestly thought that I was under the limit, but the court may find that that mistake is not reasonable. It's not an honest and reasonable mistake because there's so much publicity about drink driving and I should have known that I could have been into the low range. However, for example, if your drink is spiked or somehow someone plies you with alcohol without you knowing it, cocktail or something like that, I suppose, then you may be able to rely on that defense of honest and reasonable mistake to fight your drink driving charge.